Alex here with part 181 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the motion for order to show cause. I'm trying to hold my ex in contempt of court again. This is mostly, I think, because of her stealing the clothes again, and I think it may include a number of other issues as well. I can't remember now, though. Mindset at the time was annoyed. Annoyed because I was having to ask for the same court orders that I had already asked for in the past and that I had already got from Judge Weller. And now the new judge needs to be asked for the same stuff that I asked before, for the same reasons that I asked before. And that's all I can remember, is being very annoyed. So all that being said, we're going to really get down into the details when we actually go through what I have filed. Here we have my motion for order to show cause or for the alternative relief requested. This term means something. When you ask for something in the alternative, it's mentioned in the Washoe County District Court rules. You're allowed to do that. The reason I say that is because some jurisdictions will let you file counter motions and other ones won't. The Second Judicial District Court specifically does not allow you to file counter motions because they want it separate. They want a motion separate from an opposition. They don't want a motion and an opposition combined together. But they do mention in that same local rule that what you can do is you can ask for relief in the alternative. That's okay. So if you want to learn more about motion practice, you're gonna have to do a lot of research. There's a lot of stuff out there on that. I do have a video titled Motions that I think it does talk about this. You can take a look at that video if you want to learn more. We have standard introductory paragraph indicating myself as the petitioner, to indicating to the court that I am appearing in proper person, which means I don't have an attorney. And going forward, I will not have an attorney in this case all the way up until the very end. And it's not even really for that long. There's a hearing on adoption, and that's where you're going to see the attorney. So he pops in, does the adoption hearing, and he leaves. But all of the actual paperwork, that's still done by me. We're going to talk about that more when we get to that point in my docket series, but that's way at the end, guys. Summary: I am the natural father. My ex is the natural mother. We share a common child of age 9. I have primary physical custody with visitation rights to my ex. We share joint legal custody. My ex has refused to pay child support, has not made a payment on child support in almost a year. Wow. I thought she was going to pay all that stuff, guys. I thought the judge didn't want me to execute on her assets. I thought we weren't supposed to have a debtor's exam. Well, this is what happens. This is what happens when judges do not pay attention to the history of a case. This is what happens when we have knuckleheads on the bench. They will go to a hearing and they will say, oh my gosh, shame on you. You had to pay all those monies for the surgery, and you had to take out loans, and you had to do all this stuff to be a great dad, and she didn't pay anything, and bad on her. But we're going to go ahead and not let her pay child support for a year. That's what's going to happen. And this is because of two things in this case. The first is she had an attorney. If you want to learn more about what the judge is doing, look at the video Meta Rulings, because that explains how the judges will rule in favor of a person, not because they're right or wrong or because of the law, but because they have a lawyer and they feel bad for that parent having to pay all that money for a lawyer. They have to win something, right? And the other thing is there's a second video that talks about this problem. Well, you can look at wing it judges, which are judges that don't pay attention to the history of the case and they just wing it. And then there's a third one. I know there's a third one that's really relevant. It's, best interests of the parents. So that's where the judge becomes more concerned about what's best for the parent and less concerned about what's best for the child. These are the consequences of incompetence. There's going to be a lot more coming down in this case, not just my opinion, but the opinion of the Court of Appeals after they overturned this judge's decision not once but twice for failure to apply the law and for abusing her discretion. So all of these mistakes, I think, would not have occurred if the judge didn't make the mistakes as outlined in the video's best interest of the parents and meta rulings. Her decisions were very specifically connected to those flawed approaches, and she almost got this case right, but the mistakes that she made were big enough that they need to be discussed. We have the non-payment of child support. So my ex has child support at the amount of $571 per month. We're going to talk about the abatement later. Next, we have that I informed my ex that I hadn't received child support and garnishments, and that I advised her to let me know if she needed a few weeks to catch up. On the same date, my ex responded that request for child support should be sent to her lawyer. Okie dokie. Next we have, which isn't true by the way, next we have a notification from my ex that she intended to catch up on her child support. Next we have my ex informing me that she was no longer employed, and that she apparently is not looking to obtain employment. I don't know, maybe that's because she has her husband. I don't know. We're going to look at these emails, guys, because all these exhibits are mentioning emails, so we're going to have a lot of time to go through these. We have my notification to my ex that I expected her to cover the costs for travel, so that I could apply half of them as an offset to her child support arrearages, which is totally reasonable. That's one of the beauties of offsets. If your ex owes you a ton of money, you don't have to pay them anything. You can just say, hey, I'm going to take it out of the debt that you owe me. If you want to learn more about this, please watch my video on the topic, offsets and set-offs. We now have the court adjusting my ex's child support downward to $471 per month, retroactive to July 1st. This is because of the child support abatements. This is another thing that's interesting, guys. I talk about retroactive child support modifications in the video child support. The problem with this is that it's discretionary. Please watch my video on the topic discretion. And unfortunately, what tends to happen is that retroactive modifications are applied in favor of mothers, but retroactive modifications are not applied in favor of fathers. If you want to learn more about this, please watch my video on the topic gender bias. Going into the next section, we have I am notifying my ex again to please cover the costs of her upcoming visitation so I can apply half of them as an offset to her child support arrearages. My ex failed to respond to or even read this message. To date, my ex has an outstanding child support arrearage in the amount of $1,239.68. Legal analysis. We already know the analysis on contempt of court. I've gone over this a number of times. It is disobedience or resistance, basically non-compliance with a court's order without any justifiable basis. We're going to go into, let's see here. Alternative relief requested. Should my ex sincerely be struggling financially through no fault of her own, the alternative relief that I'm requesting is that the order continuously require us to reciprocally keep each other updated as to the status of employment. It appears that my ex is unemployed and not seeking further employment. I would request an order relieving her from her duty to provide our son with medical, vision, and dental benefits, and to transfer this obligation to me, who is currently covering the child through my insurance anyway. This would get rid of the deviation on child support that she currently has for providing these insurances, which she right now isn't providing. Again, though, this is one of the problems of gender bias. When a father is not providing what he is required to by court order, they will typically adjust the court order. When a mother is doing it, they won't. Most of this is rooted in the problem of discretion. Please watch my video on the topic discretion. I know I mention it all the time, but that explains why so much of what's going on is going on in the family court system. Non-payment towards outstanding judgment on arrearages. So we have the arrearages. Let's see, the court reduced my ex's arrearages and outstanding medical obligations to $2,998.43. My ex made a single $50 payment on the judgment. After that, my ex made another $50 payment on the judgment. After that, I informed my ex that I hadn't received payments on the judgment for child support arrearages. On the same date, my ex responded that my request should be sent to her lawyer. Next, we have October 10th. I'm reminding my ex that I've still not received payment on the judgment for child support arrearages, nor have I received the $150 in money orders that she was ordered to recall and turn over to me. To date, it has been 10 months since my ex has made any payment on the arrearages judgment, and her outstanding balance is now $3,000. Contempt is disobedience to any blah, blah, blah. You guys already know what contempt is. Here we are again talking about the same laws that the court fails to apply. Alternative relief requested. Same thing. I'm requesting that the court, well, actually, this is different. I'm requesting that the court direct the district attorney's office to start seizing monies on the child support arrearages as well. Failure to return the child's clothing at exchanges. Factual background. Let's see here. I expressed dismay to my ex for her repeated failure to return the child's clothing. My ex failed to respond to or even read the message on August 9th. I reiterated my demand on August 22nd for my ex to return our son's clothing. On the same date, my ex justified her conduct, claiming that she deliberately confiscated our son's clothing because she felt it was too small. On the same date, I responded that our child wears 6, 7, and 8, sometimes smaller because he is a small child, blah, blah, blah. So on the same date, my ex responded argumentatively. On October 23rd, I enclosed an inventory of items with our son's travel bag, advising my ex that I expected them returned. On October 26th, I contacted my ex and listed various items for the previous inventory that were not returned. My ex failed to respond to that message. On October 28th, I enclosed another inventory of items with our son. And then on November 5th, I contacted my ex and listed even more items from the previous inventory that were not returned. My ex failed to respond to or even read that message. To date, my ex has made no efforts whatsoever to return a single item of clothing that she has unjustifiably confiscated. Okay, this was predictable. Legal analysis, contempt is blah, 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 same thing. Another contempt of court issue, gigantic paragraphs on the law of contempt of court that you guys already know about. If you want to learn more about the details, please watch my video on the topic, contempt of court. Alternative relief requesting. Let's see here. I can give my ex a $25 deviation in her favor to cover the cost of clothing, and I can get another order from this court again to order the exchanges of clothing to stop again. This is the alternative relief that I'm requesting because I'm not trying to get my ex thrown in jail. I'm just trying to end the conflict. The judge actually takes this option because the judge doesn't want to deal with this case anymore. She doesn't want another hearing. She is done. These judges create all the additional work for themselves. None of these motions would need to be filed if she would do her job correctly. If you want to learn more about why family court judges don't know what they're doing when it comes to high conflict child custody, please watch my video on the topic, high conflict incompetence. Next section here, communicating with the father through the child. Okay, all communications regarding our son have to be through us whenever possible. That's the order of the court. On October 1st, I asked my ex to stop communicating visitation requests through him. On August 22nd, my ex responded that it was, quote, good parenting to tell our son to ask me. If you don't like him asking you for visitation, for permission, when he wants something, then you shouldn't be a father. That's what she said. I can't wait to look at Exhibit 20. Going on to October 28, 2015, my ex appeared at the child's physician's appointment, and after I informed her that I would be caucusing with the physician, my ex told the child to approach me and reiterate her question. So this was in an actual waiting room that she kept telling our son to come and approach me and ask me questions. She has no shame. We have legal analysis, again on contempt, same gigantic paragraph as before. We have costs and attorney fees. The statute entitles me to an award of attorney fees if I prevail on a motion for contempt. At this time, I haven't retained counsel, but if I do retain counsel, I'd like an award of attorney fees, which I don't bother with this. Mediation. Mediation is not appropriate when blah, blah, blah. You guys have seen me put this in motions a million times now. It's the same stuff that I put in my motion so that I don't have to go to mediation. And it continues to work because I don't have to go to mediation on this motion. If you want to learn more about why mediation doesn't work in high conflict child custody cases, please watch my video on the topic, mediation and settlement. Next section, conclusion. We have all the things that I'm requesting in this motion, which is multiple different contempt orders against my ex. And let's see here. An award of costs, an award of attorney fees. Declaration in support of contempt. This is my declaration, which goes into detail over all of the allegations on contempt. Declaration of my wife in support of contempt. Same thing. My wife is providing her declaration on these particular issues because she has to swear under penalty of perjury as to what she's seen. I can't swear under both of us. I have to swear as to what I've seen. She has to swear as to what she's seen. Certificate of Rule 5 service. I'm indicating under the rules that I have mailed this document to my ex's attorney. Here we have the motion opposition notice. According to this document, I do not have to pay the $25 filing fee. List of exhibits. We have a whole slew of exhibits, 20 different exhibits. Most of them are our family wizard messages. Okay, that's good. That's better than emails. That makes me very happy. Exhibit 1. All right, I'm reminding my ex about the $50 payments. I'm just reminding you that I didn't receive the $50 counter credit that was due on the 8th. Your attorney should have my account number in case he still didn't give it to you. Exhibit 2. From my ex to me. This communication should be going through the lawyer. I'm asking you to remove the calendar reminder events that you created as this is supposed to be about our son. I also don't appreciate you sending me an email, a message, a text, and creating a calendar event. That is rude. I will communicate with my lawyer about this. The lawyer doesn't say anything to me. Okay. Exhibit 3. I am communicating to my ex. Parents are expected to discuss child support payments, when due, when paid, etc. It's basically how we communicate our financial obligations. The calendar events are useful in case payments aren't made, because then the court can view that you were reminded, notified, and responded accordingly. Lawyers are necessary when it comes to modifying child support orders and such, because it comes down to filing motions and arguing points and authorities. You were only texted after not signing in for weeks on end. Now that you are logged into the wizard, you should be able to keep up with message communications without me having to send text messages, which I highly appreciate. None of this stuff is educational for my ex. She knows all this. What I am saying to her because I need to attach this to emotion, which I have done. The person who doesn't know is the judge. So I have mentioned this before in the video communications. If you know that your ex doesn't care, and if you know that your ex already knows what you're telling them, you still have to send it to them, because the judges don't know what you know. If you want to know more about why judges don't understand this, please watch my video on the topic, high conflict incompetence. I really want all of my viewers to watch that video, which is why I keep mentioning it. Exhibit 4. Let's see. My ex to me, she's saying she was polite, that once again I am lying and doing my best to keep her from seeing Army, and that I'm going to have to live with my actions. She's saying that she sent him with at least one set of new clothes every time, that I send him with clothes that are at least 3 to 4 sizes too small, that is child neglect, that she won't allow it, that she won't be sending back small clothing. So this is good, because I can use this against her to show that she's willfully in violation of the court's order. She has a basis in here that she's mentioning, which is that the clothing is too small, but that is going to be burdened upon her to prove. So by her sending me this email, she has satisfied my burden of proof on showing that she's in willful noncompliance with the court's order. She can try and show that she's justified in noncompliance with the court's order, but the onus is on her. The burden of proof shifts to her, which is what I want. So this is how you can take an email like this and use it against your ex, even though what they're saying in here seems to justify what they're saying, because this way I can make sure that when we go to court on contempt, she's the one that's going to have to prove what she's saying, not me. And she won't be able to prove this because it's not true. Ultimately, the judge takes the option of just ordering that clothing no longer has to be exchanged. Exhibit 5. Let's see. She is saying to me that if she leaves Army with somebody, she'll let me know ahead of time. That she has no reason to leave him as she doesn't have a job. Okay, we've gone over this message before. This is the one where she says that since Army no longer lives with her because she's lost custody, that she no longer has to tell me where she lives. And this is not going to fly. I'm going to be filing a motion on this. She has finally gotten the insurance changed, and the copies of the insurance cards are mailed. They didn't put his name on the cards, just her. I'm not sure how this works. I don't think I ever got any insurance cards from her because she ends up losing her job. This must be insurance cards that she got from her husband, possibly? That might be what she's talking about. Exhibit 6. This is a message from me to her. As per the telephone conference today, the attorneys agreed on the following. In the future, you are entitled to splitting alternative. Okay, so this is me just explaining to my ex how the court's order works. Exhibit 7. This is from me to my ex that I'll be at work until 5 p.m., but my wife can get him. Remember to fly him back and get the costs associated with the flight. The judge ordered that I can contact the DA and apply these travel costs to your outstanding child support arrearages, which is good. And this is really smart of me, because my ex is trying to make it financially difficult for me to deal with this relocation. And I'm basically saying, hey, since you owe me so much money, I'm not going to reimburse anything cash-wise. I'm going to reimburse everything through offsets. And this is not something that she wants, because she wants to inflict financial pain on me. So by her having to bear the full cost of these flights, it very much discourages her from using this as a high conflict point. Exhibit 8. So these are all the new arrearages. Thousands and thousands of dollars piling up. Exhibit 9. Ledger, what is this? From me to my ex, please advise on the return of those 3 money orders, which I still haven't gotten. I never get this, guys. The ledger has been updated to reflect new arrears. To date, you have made no payments. We still need your insurance information. Exhibit 10. Me to my ex again. We're still trying to figure out if you deliberately keep Army's clothes or you're forgetting to send them back. We got all of his underwear, only 2 pairs of socks, 1 pair of shorts, only 1 long sleeve red shirt, and 1 dinosaur shirt. Please give a clear answer on this. My ex is not responding. Exhibit 11. From me to my ex. Words are 10% of human communication. Your tone was outrageous and your body language aggressive. The court has ordered us to communicate with family wizard. This needs to happen. Maybe someday, years from now, you'll be able to have a healthier relationship. It is disappointing as to me as it is to you. As for future contempt proceedings, the only 3 things I can recall are not receiving the money orders or counter credit, the clothes not being returned, and the failure to communicate through our family wizard. If you can work on the following issues, no motion will be filed against you. And then I go ahead and mention these issues. The last thing I want to do is have you thrown in jail. It's absolutely the last resort, but I will resort to it if I have to, especially when it comes to keeping armies closed. I would much rather have things go smoothly between us. Exhibit 12. Let's see here. From my ex to me, she's disputing that she was not polite. She's saying that I'm lying. Oh, this is an email that we already had, so I don't know why I put it in here again. Interesting. Okay. Exhibit 13. From me to my ex. Typically have army in sizes 6, 7, or 8. I could have sworn I already went over these. If something is small, address it with us. Send a picture of him wearing it. Point it out. But when you just say you won't be sending it back, it comes off as spiteful, and it's hard to take you seriously considering the case history. Again, guys, this is not, I already know at this point that my ex isn't learning anything from this. All of the things that I'm explaining to her, she already knows. She's just doing them anyway. So I'm doing this for the court. The court is the one that doesn't know what's going on. So even though my ex knows all of these things that I'm telling her, I still have to say it because the judge doesn't get it. And this is one of the ways you can get the judge to understand without actually having to school them in court, because that doesn't work. They don't like that approach. Instead, you often have to act like your ex doesn't know what's going on and educate your ex, even though I talk about this, guys, in the video communication. I know that this is one of the things that a lot of people make a mistake on. They won't communicate to their ex because they figured out that their ex just doesn't care. But the problem is when it goes to court, their ex will lie and tell the judge that they didn't know. And so what I'm doing here is I'm anticipating my ex and her attorney's response. And I explained that tactic in the video, anticipating the response. So there are still points to making statements to your ex that they already know when it comes to litigation, because if you don't do that, your ex and their attorney will exploit the fact that you didn't do that to play dumb. Playing dumb is one of the most common ways that attorneys get their clients off the hook in contempt of court proceedings. Exhibit 14. Exhibit 14, you are lying again. This is from my ex to me. The first thing that they teach in the medical field is that clothing that is too small is a sign of abuse and neglect. Sending clothing that's too small. Okay, so she's just, once again, she's not going to provide any evidence or proof. So I'm done with this. This is when I filed a motion. Exhibit 15. Okay, so this is the inventory. This is the inventory that she returned. Oh, wait. Okay, so these are the things she has to return, and these are the things that she's allowed to keep. I think that's what I'm doing here. Inventory of, okay, with the corresponding return or keep entry. You can feel free to keep the items marked keep, but please return the others. Also, enclosed are post-its. If you have any issues with any item of clothing, attach the post-it with your issue explaining. Do not keep, confiscate, or destroy any items of clothing. Guys, what I am doing here is absolutely anticipating the response. This is not something that I am doing because I think my ex is going to comply with it. This is what I'm doing to prepare her to be thrown in jail. If you just go into court and you make it a he said, she said thing, you just make it easy for the judge to just not care and throw the case out. The judges do not want to hold your ex in contempt. So oftentimes you're not just going against your ex, you're often going against the judge. So this is my way of twisting the judge's arm into forcing her to hold my ex into contempt because I know she's not going to want to do it. So what I'm doing here is I'm making a very reasonable request. I'm saying, hey, if there are issues, just stick a post-it to the item and let me know what the issue is. I already know my ex isn't going to do that. I already know that. But I am doing this anyway because I need to win the hearing. What the problem I have isn't with my ex. The problem I have is with the judge's incompetence. So these are genius approaches at dealing with this problem, because now your ex is going to go into court and say, yeah, I confiscated those items. And then the judge is going to say, well, why didn't you do what he said? Why didn't you tell him your problem with the item? Why didn't you take a photo of it? Why didn't you take a photo of him in the item? Why didn't you put a post-it on the item? Now your ex is screwed. Now, then, what are they going to say? I didn't feel like it. He should just trust me. You should just trust me. You should just believe me that those items weren't good enough. That's not going to work. They're going to get thrown in jail. So this is me anticipating the response, just like what I did with the previous motion to modify child custody. I already knew that my ex was doing certain things. The problem is that the judge is incompetent, so I have to go above and beyond to take the judge's arm and twist them into making the ruling that they need to make. And so that's why I went ahead and used the red coat test. I mean, I was thinking not how do I, go into court and explain these things. I was thinking, how do I go into court and cut off all of my ex's paths of retreat and force the judge to make the decision that they need to make for the child's best interest? If you want to learn more about that, please watch the video. Anticipating the response, because that's the mindset you need to get into when you're dealing with these judges. Exhibit 16. Let's see here. Just an FYI, one pair blue shorts and the belt are missing. If you are missing these items, please make efforts to return them. This belt is the belt is extra important because it's a school item. So this is me communicating with my ex again. Even though she still fails to comply, I still make sure that I send messages that show myself as being cordial, because I know this is going to end up in court. Exhibit 17. Here is our response to the inventory issues. So the items that we got back are checked. The items that are missing, we put in here. Exhibit 18. Mrs. Me again communicating with my ex. We're missing beige school pants, long sleeve navy school shirt, blah, blah, blah. Still letting her know that stuff is missing. I still want to show the case. I still want to show the judge that I'm being as cordial as I possibly can. When it comes to throwing your ex in jail, you really have to show the court that you're doing everything in your power to try and avoid that. And you want to show the court that your ex is doing everything in their power to force that to occur. That's the only way you're going to get these judges to actually do what they're supposed to do, which is to hold your ex accountable for their actions that are damaging the child. Exhibit 19. Here's another email from me to my ex. It looks like, I'm all about talking about this stuff. That's one of the reasons I'm excited to use the wizard. After years of poor communication, it looks like we have a chance at some real work together here. Now, I already know this isn't true, but again, as I explained in my video communications, the judge doesn't know it's true. So since the judge doesn't know it's true, you still have to keep putting together paperwork like this to really get it through the judge's head that this is a problem. Just because I know that my ex isn't going to really believe any of this stuff doesn't mean that I shouldn't say it. I need to say it to get it in writing so that it comes up in court in my favor. Again, guys, watch my video communication. I explained that this is one of the things that we have to do, even though it's frustrating because your ex already knows what they're doing is wrong. This is just how you have to communicate to get the judges to understand what they don't understand. Moving into the next section. Oh, that's it. So that's everything. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would definitely have had to review this and discuss it with my ex, definitely. And so with all those pages to go through and those communications as well, it's hard for me to say it would have just been a 15-minute go through. It was probably closer to 30 minutes. There may have even been a discussion between him and my ex. I mean, I'm less inclined to say an hour. That mainly would go into him preparing his opposition. So I think 30 minutes is reasonable under the circumstances to review the motion. And that at the rate of $250 an hour is going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below. And I will see you guys next time.